may presume, please open your BERAC. Yeah. The other examples of may presumes may also be seen from the Indian Evidence Act, section 86, 87, 88 and 90. We'll deal with this, then other section I'll come to. Now, this chapter section 74 onwards, as I told you, that deal with public document. The public documents straight away come on record. You are not required to examine the public authorities like the President of India, judges of the court, certified copy of the court order, any order of the Supreme Court, High Court, any court of law, you can straight away come. Then private documents you are required to bring. Then certified copies of the public documents come on record as secondary evidence under section 73. That is it. Then 77 onward, proof of document by production of certified copies is allowed, part of the official act. Now, for the purpose of our section 1 may presume. Now again you can see presumptions, they are starting from section 79 onward. For the purpose of may presume, 79, 80, 81, 82, 83, 86 are not relevant. 86 is relevant. Please come to 86. Please come to 86. Presumption as to certified copy of foreign judicial records. The court may presume that any document purported to be certified copy of any judicial record of any country not forming part of India or of a majesty dominion is genuine accurate if the document purports to be the certified in any manner which is certified by the representatives of the central government or the country to be in any manner commonly used in the country for certified copies of judicial record. Now, this section can be invoked for the purpose of suits that may be filed under section foreign awards. You learned it here. We learned it in the Code of Civil Procedure Code. Certain suits are filed when judgment of a foreign country is conclusive, not conclusive. Section 13 के अंदर है and section 14 में भी check किया. Presumption onto 14 judgment. Now, section 86 to be read along with section 14 of the Code of Civil Procedure. Section 14 says, the court shall presume upon the production of any document purported to be certified copy of a foreign judgment. Now, the expression used here is shall presume, that is mandatory, that is in the nature of a irrebuttable presumption. But in the Evidence Act, it is a may presume. Okay. Now, there is a overlapping here. So, section 86 is invoked here when you seek to challenge the decree and award of a foreign country. Now, you have a Geneva Convention award. You have the New York Convention awards under the Arbitration Conciliation Act. You may take up the plea that the award when passed by the arbitrators in a foreign country and the property is sought to be attached and put in execution, you have to come to, in the city of Bombay, such awards are executed by in the Bombay High Court. The Bombay High Court exercising original jurisdiction because it is a district court for the purpose of Mumbai. Apart from Mumbai, other places it is a district court, the Thana District Court, Kalyan District Court, Pune District Court. In the city of Bombay, we are confined to the Bombay High Court. In the Bombay High Court, when you seek to challenge the foreign award, a foreign decree, then the certified copies which you may produce and bring, the court may presume that here they are valid documents, but that presumption can be rebutted by the other side. It is a rebuttable presumption. The defendant may take up the plea that here I dispute the correctness of the document here. You let him challenge it here. Now that provision with regard to challenge, under the CPC is a substantial provisions are contained here. So I am on the point of admissibility of the document under section 86. Yeah. Then you come to 87 and 88. Then presumption as to books, maps and charts. Court may presume that any book which it may refer to information on matters of public general interest, that any published map, chart sometime, or which are relevant fact, which is the produce for the inspection, was written and published by a person and at time and a place by whom or which may purport to have been written or published. So the court will presume that the Google Maps are correctly showing the destination of a particular party, or certain books written by eminent authors or leading books on a particular topic. So the presumption is that here such books, a book written by, for example, judicial authorities, some well-known Eastern law publication or a foreign publication in England or America, wherever foreign country, Indian country. So they are normally given credence by the court of law. The court may presume that they can be received in evidence. So the court may accept it here, pass an order under section 136. So normally when you tender a document, because a plain written statement के बाद the court frame the issues, then the list of document are tender. In the examination chief के साथ में you are tendering your document. Examination chief and you are required to submit a list of document. The plaintiff also relying upon the list of documents along with the examination chief, or cross examination के अंदर में you have to prepare the list of document. This is the document A, B, C, D which I am relying upon. So when you rely upon the document, so when I mentioned to you that number one, the court will see whether the document which is sought to be produced by the party is in fact in issue. Number two, fact in issue will be covered under the provisions of section 5 of the Evidence Act and section order 14 of the CPC. Secondly, otherwise, if it is a relevant fact as mentioned between section 6 to section 55 of the Evidence Act. So that is the relevancy part. Then the next is admissibility part, whether it should be admissible or not. That admissibility order is passed. Once again, I would like to draw your attention to section 136. Please, this is a very crucial section. Mere admissibility, you come down first and explain section 136. See that this should have been in the earlier 135 order of protection of examination of witnesses. Now order of protection and examination shall be regulated by the law relating to, for the time being, in CPC and CRPC, and in the absence of the law, by the discretion of the court. So under the Code of Civil Procedure, order 16 is the section which deals with the witnesses and documents. Under the CRPC, you learned that section 91, 92, 273 से लेकर 299 is the section relating to evidence. Then section 200, in a private complaint, what evidence is led. In a session trial, there is a specific section, what evidence is to be adduced. Then in a warrant cases before a magistrate, what evidence is required. In cases otherwise than a warrant cases, what evidence is required to be given under the provisions of the CRPC. Then in summon cases, what evidence is required to be given in CRPC. So that has to be read along with this is the meaning of section 135. So there are various examples in the CPC and the CRPC where evidence can be reduced. So you have widely gone through it. If you want to just recapitulate your memory, I will just please take out your CRPC. I will bring to your attention in what cases evidence is allowed by the court. Please, number one. First number you take it here. Starting section 200 में देखिए आप examination of the complainant. Now here the learned magistrate examines the complainant before issuing the order of process or before passing an order of investigation under 156(3 or before issuing an order of inquiry under 202. Now at this stage, when the magistrate examines the witnesses, there is no cross-examination because the accused is not present. Kindly remember that. The accused is not present here. At this examination, I will give the famous case of Salman Khan case, why he got acquitted because of this section. Now, in this section, at the time of taking cognizance, the accused is not heard. It is not like a civil case where you file a plaint, your number is given to you. In a criminal case, in a private complaint, under section 190, you file it, your examination is recorded under 200. The court asks the complainant to come in the box. The court may also tell you want to examine any witnesses. This is one section which tells you examine yourself, examine the witnesses before I take further steps in the matter, namely to issue process against the accused, whether he should appear or not. If the magistrate is not convinced, he will not allow it. The accused has no right to participate, say that merely I come to know, case is complaint, I want to cross-examine. No. You know, in the 304A case against the actor Salman Khan, you know why he got acquitted? At the time when he committed the offense, namely he drunk driving, 3-4 people who were sleeping at the pavement were killed. The constable who was sitting as his guard, he was the eyewitness. And he went and lodged the FIR to the Bandra police station. Hello? Any problem? Yeah, he went and lodged FIR. I beg your pardon? Anything?
No, sir. I think she thinks that your voice is breaking up. I think it's a local issue. You're loud and clear.
I am loud and clear, no?
Yes, sir.
Yeah. So, the Havaldar, who was the eyewitness, went and lodged the FIR. Now, since the offense under 304 is a non-cognizable one, the learned magistrate directed the Havaldar to come and give evidence. In the deposition under 200 examination, he deposed the incident he has committed. Of course, obviously there was no cross-examination. Isn't it? Now this examination, this evidence which was given by the gentleman in the 200 cannot be used in subsequent proceeding. Please note that, because he had no opportunity of cross-examination. Only when a witness had the opportunity, other side, to cross-examine, his part of the evidence can be used in other judicial proceeding or in the same proceeding at a subsequent stage in the same court or in session court pursuant to section 33 of the Evidence Act. That I will come to later. So this is one stage where evidence is recorded. Now, second stage, see, you learn before a court of session, trial before a court of session, section 231 kholiye aap. Evidence for prosecution, section 231. Can you please open 231? You got it? Yes. So 135 say order of protection examination. So when a session trial, a murder case, a rape case, a robbery case taking place, so the prosecution leads his evidence here under the provisions of section 231, and also the prosecution leads his evidence. What is one trial before the court of session? There is one more trial that is known as a trial of warrant cases before the magistrate, starting from section 238 onward. Here the evidence is dealt under section 242. Now please open section 242. 242 खोल लीजिए आप. 242 के अंदर prosecution leads the evidence and 243 defense evidence. Got it here? So you should read your section 135 of the Indian Evidence Act in conformity with the provisions of section 242, 43 for a warrant case triable by magistrate. Then you have summon cases triable by a magistrate starting in chapter number 20, that is section 255 onwards, say like a 259. That evidence is recorded here. Procedure when the accused is not convicted. See, acquittal. Evidence to be recorded, section 254. 254 is the section where evidence is recorded. Then summary trials. Now the word, when you see open section 254, you will come to know that. Yeah, section 254 का खोल लीजिए आप. Yeah, 254 के अंदर यहाँ पे मेंशन किया गया है, if the magistrate does not convict the accused under 252, 53, magistrate shall proceed to hear the prosecution and take such evidence as may be produced. So the magistrate is enjoined with a duty to take evidence. So this is in conformity with section 135. Okay. Then again, the word evidence in a summary trial can be taken under section 262. 262 खोलिए आप. Procedure for summary trial is the same as the one in the summon cases. When it is the same procedure with regard to evidence should take place. So these are the various examples in CRPC where evidence can be taken by the magistrate and the criminal court. Now, as regards CPC, of course, you are now very much clear. That is order 16 के अंदर summoning and attendance of witnesses. Please bear in mind, order 16, list of witnesses, summons to be witnesses. Entire order 16 deals with the summon witness. Then order 18, rule 4. Under order 18, order 18 tells you hearing of the suit and examination of witnesses. So CPC के अंदर you are required to know section 135 of the Evidence Act should be read along with order 16 and order 18 of the Code of Civil Procedure, which deal with hearing of the suit and examination of witnesses. So this is an elaborate procedure. When we took CPC lectures, it is there. And those who could not attend my lectures, it is there also in the YouTube, that you may follow it up. And even if you read the bare act. So 135 is a very important section. 135 clearly says that the order in which the witnesses are produced and examined shall be regulated by the law relating to CPC and CRPC. Don't forget it. Then, if the law is not there, then discretion of the court. That means following justice, equity, and good conscience. There is no question of justice, equity, and good conscience there because both CPC and CRPC learn. Now, 136. Now you are brought before the court of law all the evidence as the CPC and CRPC tell you and the list of documents. The next step is whether the documents and evidence you brought before the court can be admissible before the court. Because relevancy is one thing, admissibility is another thing, and proof is a third another thing in the Evidence Act. Now, we are proceeding on the second most important limb of the Evidence Act, namely the admissibility of the evidence. Now, section 136 says that when either party proposes to give evidence of any fact, the judge may ask the party proposing to give evidence in what manner the alleged fact, if he proved, would be relevant, and the judge shall admit the evidence if he think that if he proved would be relevant and not otherwise. So at this time, when your examination chief is tendered or your list of document and cross are tendered, the judge will ask the cross-examining counsel how this document is relevant. You please tell the court. If you have produced a will, you may say that A may say that my grandfather's will bequeathing the property to me, and your brother is challenging his signature. So the question before him, should I take the will or not? Copy. Is it a copy or original one? So whether the witness has signed it or not. So the judge will examine the admissibility. Can it be admitted or not? Whether it's a document, is an agreement which you have produced before the court, which is not sufficiently stamped. The court will say that, sorry, I cannot admit this document. Because there's a bar under section 49 of the Registration Act. And similarly, he will say that the will which has been produced by you, it is signed by only one witness. How can it be? You require minimum 2 witnesses. Isn't it? So the judge may say that I will not take up this document, it will not be admitted. At the most, he will say the document taken on record for the purpose of identification. That means the plaintiff may lead other evidence. But if the court is satisfied that yes, he has produced, suppose you are relying upon a passport or ration card or maybe your election record. Yes, election record is a public document within the meaning of section 74. I will admit it. Public, your school leaving certificate is a document which is coming from proper authorities. I may take it on record, subject to examining the school authorities. So the court will pass an order as regard the admissibility under section 136. Please note that section 136 is a very, very important section which comes into play immediately when the evidence commences before the civil court as well as before the criminal court. Unfortunately, this section is kept very much behind, and I'm sure many of us must be skipping this section. This section is very important to remember, that the order, in a chronological order, you must remember here: plaint is filed, written statement is filed, issues of frame, then examination chief, list of document. List of document file करने के बाद, then the matter is come up before the judge. Then the judge will, you lead evidence under the provisions of order 16, order 18, after exchanging the list of document under order 16, rule 1 and 2, and in the CRPC and that we have mentioned, section 90 and 91. Evidence is being led by you, section 273 onwards till. When that is so, the learned judge will ask you question: prove this document, how it is relevant, how it is connected. Then when the finding is recorded of the learned judge, you have a right to challenge this finding later on in appeal also. Please note that. Don't get rattled. The learned judge has given a finding not taking on record your document. At the final hearing of a case, any party has a right to say that this document is a public document or a relevant document under section 90, 30 years old document, should have been taken by the judge at the time of the interlocutory stage or evidence stage, which is not taken, but at the final hearing stage, your lordship may consider. Even at the final hearing stage, if a particular vital document is not come on record, you have a remedy under section 105 CPC. You remember 105 CPC, any one of you? Please inform me. You have a remedy under section 105 CPC. When earlier no appeal was filed, subsequently you have a right to urge the appeal. Remember that section? Section 105. I will recapitulate for your memory. Yeah, it is. Yes, 10. Yeah. See, 105 deals with save as otherwise expressly provided, no appeal shall lie from any order made by the court in exercise of its original appellate jurisdiction. But where a decree is appealable from an error, defect, or irregularity in order affecting the decision of a case may be set forth as a ground of objection in the memorandum of appeal. So here you may take up the plea that the order passed by the court not admitting your document is suffering from the vice of a defect, irregularity. The evidence, material evidence should have been recorded. For example, there is a written document filed by the plaintiff, registered document. You take up the plea that the agreement is sham document, colorable document. I wanted to lead oral evidence to challenge it. The learned judge rejected by evidence. So you cannot challenge it during the course of the appeal. In the subsequent proceeding, when you file the main appeal challenging the order of the decree, you may urge this ground. The trial court has manifestly committed an error apparent on the face of record and disallowing me oral evidence under section 92 of the Evidence Act, which ought to have been allowed. So as an alert lawyer, you should know this section, and under 105, you are permitted to lead it here. Suppose, because at the time when evidence is recorded, you cannot file the appeal. There is no appeal against interlocutory order. And there is no revision against the interlocutory order, is not a judgment. There is a bar under section 115. You know that now here. In the CPC, there is a bar. But in the CRPC, there is a wide power under section 397 to the Court of Session and to High Court under section 401, 402. But whereas our revisional orders under the CPC under 115, there is amendment here. Unless the order is finally disposing of, it's a decree, it's an order. Final order, you cannot file the revision. So that means you are not remediless. So when the judge has not permitted you to accept a particular document, you have a right to urge, make submission at the time of your final argument. Means when after the closure of the entire evidence, my lord I would like to submit that here the plaintiff had filed a written document which I had challenged. I took up the plea that the document is suffering from the vice of fraud. There is another document, oral document, which says that here this document not to be acted upon, as it is sham document, colorable document. I should have been permitted to lead evidence. And this honorable court be pleased to take into consideration that evidence and pass the order in my favor. If the learned judge, a trial court, does not pass orders in your favor or does not comment upon it, or if he gives an adverse finding against you, not to be disheartened. Under the provisions of section 105, when you are challenging the first appeal under section 96, you can urge this plea that the learned trial judge at the stage of recording evidence committed an error of law by not allowing me to lead oral evidence. That you are allowed to do that. Okay, that you remember section 105 very well. So this is the meaning of section 135. 135 tells the order of protection examination is governed by CPC and CRPC, which I pointed out to you right now. Then when this procedure is completed, then the learned judge, when each document is coming on record, the judge will give a finding, yes, the plaintiff has produced, for example, agreement of sale. It is signed by both the parties. Defendant has given objection or no objection. In my opinion, it is sufficiently stamped and it is signed correctly. The document can be taken and recorded in evidence because it is a suit for specific performance of a contract. That plaintiff is alleging that defendant builder has committed breach of this agreement. The suit is filed for specific performance, for possession and for rectification and for incidental order. So in my opinion, it is a relevant document. It can come on record. It can come on record and the same can be exhibited. But at the same time, if the document is not stamped, unregistered, it is not signed by the parties, the court may give a finding that this document is supposed to be an agreement of sale. Under the provisions of section 17, it has to be registered. Under 49, it is not registered. The effect of non-registration is document cannot be taken. But the proviso provides that an agreement of sale can be taken on record. In cases which is relating to specific performance of a contract or for leading collateral evidence. Collateral evidence means that I am challenging the registration of a document. The original document, I want to lead oral evidence. Apart from the written document, there is a separate agreement between the parties. That is the meaning of collateral evidence. Mean to prove that here the plaintiff wanted to prove out of the document A thing, but I want to establish B thing. I want to nullify the submissions of the plaintiff and establish my own submission in that regard. So he is alleging that it's an agreement of lease. I am alleging that it is not an agreement of lease. It is agreement of leave and license. It's an agreement of conducting, or it's a agreement of subletting. It's a sham document. So that is how it is done. The court may say that here the agreement is duly proved, I am taking on record. Or the court may say that the document is not sufficiently stamped, I am not taking on record. The document may be impounded, sent to the collector for examination. In the case of a title, under section 54 of the Transfer of Property Act, if you are establishing a title, you must have a conveyance in your favor. You must have property card. It is not there. The plaintiff is unable to prove it here. But if you lead circumstantial evidence, consideration, witnesses, the court may consider it. So here the court passes an order. The will is produced, the signature is correct, the will is taken on record. The contents may be different. The court will see whether the signature is of a testator, number one, whether the testifying witness has deposed that he has signed the document in the presence of a testator along with the other witness. So this witness has clearly said. So the provisions of section 68 are attracted to that. See, section 68 says that in cases of will, minimum one of the witnesses must be examined. See that? Proof of examination of document requiring by law to be attested. If a document is required to be law to be attested, it shall not be as evident, use evidence, unless one attesting witness at least has been called for the purpose of proving in execution. If there is an attesting witness alive and subject to the process of the court and capable of giving evidence, provided that it shall not be necessary to call attesting witness in proof of the execution of a document, not being a will which has been registered in accordance with the provisions of Indian Registration Act, unless the execution of by the person to whom it purport has been executed is specifically denied. So, इसीलिए lawyers are advising people, your will should be registered. It is not mandatory. So, when a will is registered under the provisions of the Registration Act, Section 58, it is deemed to be correct, presumed to be correct. So, the law says that unless the defendant is challenging, your brother is filed in before the court of law a probate petition on the ground of a will of your grandfather or father. It's a registered will. Unless you have challenged the registration, the will be accepted. If you are challenged it, the court will not take on record. The court will take on record your submission. The court will say that at least one attesting witness should be examined under section 61. Then it is only after that the court will say document is marked as exhibit A, plaintiff ka to P1, plaintiff document. Defendant rahega to D1, defendant document. P1, D1. If the court records it as a document is a marks X for identification, means document is not proved. The document is not admitted in evidence. I'm sorry. The mere admission of a document by giving exhibit is not a proof. Please note that. That proof part is the third part, which we will deal later on when the next part is come. So we are today on the second part. The first part is the following the procedure laid down in CPC and CRPC with regard to evidence, examination chief, list of document. The second part is the court passing an order with regard to admissibility of a document under section 136, whether the document is correct or not, taken on record. So the judge gives findings accordingly. If a document is correct, he says, yes, I am admitting the will. It is approved by the witnesses. It is marked as it is marked as a P1 plaintiff document. If it is not accepted by the court, he will say mark X for identification, because it is kept open for the plaintiff to examine witness later on. That means the court can right away not reject a document. So both the parties are given opportunity to prove and disprove. The plaintiff will try to prove the document by examining the witnesses, and the defendant will try to disprove the document by showing that this is not my grandfather's signature. This signature is differing from the signature of my grandfather in his passport, in the diary which he usually writes every day. On the last day of his death, he wrote a diary, and you may compare the signature. Section 73 can the court can compare the signature, or under section 45, 46, 47, court can appoint a handwriting expert who will be examined. The court will give a finding. So there are so many avenues open for a trial court and parties to lead evidence. Your doors are not shut. So merely because you do not have a direct evidence, not to worry. You may rely, every matter has some kind of evidence. It may be documentary evidence, oral evidence, it may be circumstantial evidence, it may be secondary evidence, it may be presumptive evidence. So you should know the legal provisions of both CPC, CRPC and Evidence Act. Then you will be able to do yes. Okay. Now come to other section. Section 87 हो गया अभी. Yes. Court has taken record your map. 88 में 88 check करिए. Presumption as to telegraphic messages. The court may presume that a message forwarded from a telegraph office, अभी telegram तो बंद हो गया ना, to a person to whom such message purported to be addressed correspond with message delivery for the transmission of the office from which the message purports to be sent, but the court shall not make presumption as to person by whom such message was delivered. So formally now presumption, now telegraph has been now deleted. I think it is no more in existence. Prior thereto, people were depending upon all telegraphic messages. Telegraphic messages under the control of the government of India. So that normally, if you give a telegraph from Bombay to Delhi or Madras, the court presumes that the message has correctly gone. The court may draw a presumption in that regard. That is section 88, and the court may admit the document under 36. Now come to section 90 now. Section 90 is an important document. It's a very old document, 30 years old document. Presumption as a document 30-year-old, where any document purporting or proved to be 30 years old is produced from any custody, which the court in the particular case consider proper, the court may consider that signature and every part of such document which purport to be in the handwriting of a particular person is in a person's handwriting, and in case of a document executed, attested that it was duly attested and attested by a person to whom purported to be executed, attested. So the court draws presumption that it is validly executed, validly written, signature is correct. The court will take on record, and court may presume that this document can be admitted in evidence. Now let us see the illustration, explanation. Documents are said to be in proper custody if they are in the place in which, under the care of a person with whom they would naturally be put by custody in proper and proved to have had a legitimate origin, if circumstances of a particular case are such to render such origin or original probable. The explanation applies to all section 81. Now section 80 can be invoked in what kind of cases? I will just give you some examples. Sorry. Now suit is filed by the plaintiff for declaration that he is the adopted son of Mr. X. Which is disputed by the brothers and sisters of the so-called father. He died 40 years ago, 30 years ago, leaving behind substantial estate and properties. तो प्रॉपर्टी के बारे में डिस्प्यूट under the Hindu Succession Act, the son will take away the entire property. The son is not there, brother and sister will take away. Third degree heirs. So naturally, the brothers and sister are interested in denying the proposition, the contention that he is the adopted son. वो बोलेंगे, my brother did not marry only. He never took him in adoption. Now, for the purpose of proving the adoption, A may rely upon the school leaving certificate, where about 30, 35 years ago, now he's 30, 40 years ago, when he was a child of 2 years, 3 years, when he took in adoption, he went to the school, and in the school form, he filled up his name as his father and shown him as his son and signed it, admit ho gaya. So the A can, to prove the adoption, that he was the son, he can prove the villagers, there may be a custom in a particular community. There may not be a written document. In the Hindu law, you do not require that you must have a written document. If customs prove that at the age of, below the age of 15, you were taken in adoption, you examine witnesses. So the school record is a corroborative piece of document to show that it's a 30, 35 years old document. The court will take on record and believe the statement. The explanation will come into picture. So this document is properly kept in the custody by the school, in the management, who normally retains the school leaving certificate. And the application form is filled by the parents. Certified copy is brought before the court of law. So the court will presume that yes, this is the entries which are shown in the school record, in the application form, which the father, the adopted father, has filled up correct. So this will be straight away admitted. But the other side can lead rebuttable evidence to show that it is a fabricated document. My brother died, the so-called adopted father died 10 years earlier than what is shown. I got the death certificate. We had done the cremation. And he was not married. He did not take him any adoption. That is how they dislodge the presumption. Otherwise, primarily, it's a prima facie. The court will believe the document to be 30-year-old and the court will straight away admit the document. But it doesn't mean it's a gospel truth. The other side has a right to, as a lawyer for the defendant, you must do a lot of investigation. Whether the plaintiff has played a fraud, whether the plaintiff has managed with the school authorities, whether how, in what connection he could do it, his social roots you can find out. Where was he born? His real parents and neighbors. ये सब चीजें आपको, you have to do thorough investigation. If you are able to lay the hand, correct evidence, material evidence, you can dislodge that here. The entries made in the school record are fictitious and false. This is in fact school run by his own family people. He himself is a trustee. He has maneuvered this document. There are many ways of saying that, isn't it? So, prima facie, the document can be taken on record under section 90 of the, then देखो, presumption also electronic record के बारे में 5 year old. They are not allowed to, not 30 years old. 90A is where any electronic record purported to be proved for 5 years produced from the record, court so and so consider, court may presume. Section 90A is if a message from WhatsApp or Messenger or from your Facebook or communication from any electronic device is produced within 5 years, the court will presume that it's a correct one. You have a conversation recorded of 5 years ago in your mobile phone, you can prove it. It's a primary evidence directly in your mobile phone. But normally nobody retains mobile phone for more than 1 or 2 years. You discard it. तुम बोलेंगे मैंने हार्ड डिस्क के अंदर ये पूरा कन्वर्सेशन रखा हुआ है. So the hard disk conversation becomes a secondary evidence. That secondary evidence is acceptable under section 65B of the Evidence Act. Kindly just come back to section 65B. 65B कहता है admissibility of electronic record, you have to obtain certificate from the authorities. This I will take a separate lecture on it. It's a very lengthy provision. I will keep two lectures, two taking for primary and secondary evidence. So 90A prescribes 5 years, whereas private documents are 30 years old, where the court can draw presumption that document. Then another provision with regard to may presume, you will find in डाउरी डेथ वाला दिया था ना आपको, मैं क्या दिया था? Yeah. Yes. Yes. These are the various sections. Then presumption as to electronic agreement. Yeah. These are the various examples of may presume. Now let us now turn to today. Next is a shall presume. आ जाइए section 4 में आ जाइए. Come back to section 4 please. The second limb of section 4 is shall presume. Whenever it is directed by this act that the court shall presume a fact, it shall regard such fact as proved unless and until it is disproved. So here one more, the court gives more strength to the supposition shall presume in comparison to may presume. May presume is little weaker evidence which can be dislodged. Shall presume is also a slightly better one. The court, having regard to the fact that believes it's a little more positive evidence. At the same time, though the court is drawing inference by holding that it shall presume that the evidence is proper, correct, document is correct, at the same time an opportunity is given to the other side to dislodge the presumption of shall presume by allowing evidence in rebuttal. Now the examples which are given under the Evidence Act for shall presume, you may kindly see section 86 onwards. 79 से आ जाइए आप. 79 presumption as to documents. See, the word used is shall presume. See, presumption as to genuineness of a certified copies. The court shall presume to be genuine every document purported to be the certificate, certified copy, or other document which is by law declared to be admissible as evidence of any particular fact, and which purports to be duly certified by any officer of the central government, state government, or by any officer in the state of Jammu and Kashmir who is duly authorized thereto by the central government, provided that such document is substantially in the form and purports to be executed in the manner directed by law in that behalf, the court shall presume, that court shall also presume that any officer by whom such document purports to be signed, certified, holds, when signed it, the official character which claims improper. So you, as a student of the government law college, you made an application to the authorities under Right to Information Act. बताइए कितने स्टूडेंट को आप एडमिट किए हैं फर्स्ट ईयर में, सेकेंड ईयर में? Why I am not getting admission? I got higher marks and people with lower marks have got it. So under the Right to Information Act, they'll give you a certificate. It is duly signed by the information officer. So the law presumes that the certificate is genuine. You make an application for mark sheet, which is not traceable loss here, that give me a Xerox copy. Under the seal, the principle of the law college gives you that seal is presumed to be a genuine document. The court shall presume it to be genuine. You make a certified copy to the collector of your property card, of assessment record to the municipal corporation, a rateable value. So these are government officers who are a state with it, or an instrumentality of the state within the meaning of Article 12 of the Constitution of India. So they are discharging official duties, statutory duties. So the court will take cognizance of the statutory nature of the duties and presume that, and whatever certificates issued and entries made by them are correct entries. Unless the other side takes up the plea that they are fraudulent documents. When you make an application, give me a certified copy of the ration card, a certified copy of the electoral records, a certified copy of the judgment and decree passed. So these are all passed by the officers under the government of India, the state government of India, officers of relating to territory of Union Territory of Jammu and Kashmir. So the presumption is higher. Okay? That is normally not doubted. At the same time, once again I tell you that here, the defendant may challenge it. This has been obtained fraudulently. This is a forged document. The principal or collector has not signed this document. There are in the market many people who are giving you forged signature. University degrees are, many of them are forged. You know that now, many of the, it's coming in newspaper, many people seeking employment are producing bogus certificates that they are holding MA degree, PhD degrees. They're coming, they're duplicates. Many are duplicates. So many people are losing their jobs. So when the matter goes to the court of law, when a contentious issue arises, a disputed fact arises here. So when you tender the document and record, the defendant has a right to take up the plea that here, this is a fraudulent document. You may examine the university authorities to prove that here serial number is not matching. And in the year so and so was not the vice chancellor. In one of the cases, I know that in the one of the issue before the court was subletting. The tenant has, without the consent and permission of the landlord, sublet the premises. With a view to avoid eviction decree, what does the tenant shows? I have been in possession of the premises from the year 1950 onwards. What is he producing? PIN code number of Bombay in the year 1950, when PIN code never came. PIN code came in the year 1960. So inquiries karo aap iske. So there are many documents produced here. So I gave you an example, bogus degrees are produced. Government seals are also in the market, they are produced, bogus. So only in the cases of genuine documents, the court presumes. The court has to be vigilant. The councils have to be vigilant that the document which is sought to be produced is a genuine document. Then next 80. Presumption as to document purported as record of evidence. This is very important. In CRPC में पढ़े आपने, बताता हूँ. Whenever any document is produced before any court, purported to be record of memorandum of evidence, or of any part of evidence given by witness in a judicial proceeding or before any officer authorized by to be taken evidence or statements, confession, or by prisoner or accused person taking taken in accordance with law, purported to be signed by the judge or a magistrate, such officer as aforesaid, the court shall presume that the document is genuine and the statement as to circumstances under which it was taken, purported to be made by the person signing it, are true, and as such evidence, statement, confession was taken down. So here authenticity is given to the documents prepared by the public officers like judges, magistrates, judicial officers. You know that confession can be only made before a judicial magistrate under section 164 CRPC. Section 2425 Evidence Act will tell you you cannot, confession made before a police officer is illegal. Confession can be made only before a judicial magistrate, not even executive magistrate. So that the judicial magistrate is enjoined with a duty to prepare a memorandum of the confession. He must tell the accused that I am warning you not to make the confession. That will go against you. Despite my warning, you want to make it, yeah, I will record it. So memorandum बनाएंगे वो, memorandum बनाएंगे, that is an evidence before the court. So when this confession recorded by the judicial magistrate tendered for the purpose of pardoning, then accomplice for whatever reason, A, B, C reason, or for using it under section 30 for confession, there is no need to basically examine the magistrate as a witness. The court of law will presume that the memorandum prepared is correct unless the accused takes up the plea that I was not in a good frame of mind. I am challenging it. I never said this. And this is not my signature. And I want to examine the magistrate. So that is, he has the right to lead evidence to rebut the confession. There is no bar. That is the meaning of a shall presume ke andar. So section 80 example. Then you learned under the CRPC, scheme of CRPC, how evidence is to be recorded by the judicial magistrates. Judicial magistrate first class, second class, isn't it? They are required to prepare the memorandum of evidence. That is, आपने सीखा होगा. If you just open your CRPC, I will point out the correct section to you in that regard. The chapter number 23 in the CRPC, check करें आप. Starting from section 273 onwards. Then see that here, deposition of witnesses, how it is recorded. Commissions are recording evidence, memorandum is prepared, section 284 के अंदर. 281 deals with the record of examination of the accused before the magistrate. So bear in mind where the memorandum is prepared. So these are all recording of the evidence of by the judicial officers. Evidence is taken down, most probably in the presence of the accused, that is section 273 mandates. but sometimes his presence can be dispensed with in certain circumstances. Section 274 देखो makes a memorandum of substance of evidence in the language of the court. See section 274. In summon cases before the magistrate, in all inquiries under 145, 148, inclusive, proceeding under 446 otherwise than in course of trial, the magistrate shall, as the examination of each witness, proceed to make a memorandum of substance of the evidence in the language of the court. So this memorandum is falling within the meaning of section 80 of the Evidence Act. And under section 164 CRPC खोलिए आप, kindly open section 164. Recording confession and statements. So this, when you read the provisions of section 164, it is clear that the metropolitan magistrates or a judicial magistrate, first class, second class, he records the confession and prepares the memorandum. Okay, that is coming under section 80. So authenticity is given to this document. The court shall presume that it is a valid document, a genuine document. Under section 4, and evidence the court may take on record and give a finding under section 136 of the Evidence Act. Yes, this is the memorandum prepared by a judicial officer, the seal of the officer, and it is not disputed by the other side. It is taken on record and marked as exhibit. If it is disputed, then the court may say that it is marked for identification. The concerned magistrate may be examined. There is no bar. Okay. Then kindly see section 81. Presumption as to gazettes, newspaper, private acts of parliament and document. The court shall presume the genuineness of every document purported to be of London Gazette. So at the time when the act was passed, 1872, Government of India Act was not there. So we were governed by the Privy Council. So London aa gaya. Now it should be amended later. The official gazettes are with the government or any colony dependent possession of the British Crown. So you may replace it to Indian Parliament. So the laws made by the Parliament, legislation, proclamation and ordinances, whatever, the court may presume, shall presume that they are genuine documents. The gazette which has been published of the Government of India, the gazettes every state government, central government is publishing. So the court will presume that you need not examine the parliamentarian as a witness to the court. So normally they not only come under 81 as the presumption, they also come under section 74 as public document. Okay, please note that. Then 81A, gazette in electronic form. The court shall presume the genuineness of any electronic record purported to be the official gazette. So from the ministry, parliament as well as legislature, there are many official gazettes are coming on record in the mass media now. So they are presumed to be genuine one. Then 82 speaks of admissible of document without proof of signature. So in those days of king and queen, when the charters were present, when the East India Company was functioning in India, so we were ruled by the English people. So whatever laws, document they brought us, charter, Magna Carta, the Bombay High Court, original site, second rules are based on a document known as what document is a letters patent. So they are all documents which the court shall presume to be genuine. So there is no question of challenging it because you can't examine them. 83 speaks of maps of the Government of India. So the court shall presume to be genuine. Then presumption as to collection of laws and report decision. Decision reported in Supreme Court cases, AIR manual of the Supreme Court and Government of India passing orders. They're all documents which can be taken on the record. Then presumption as to power of attorney under 85. The court shall presume that every document purported to be power of attorney to have been executed and authenticated by notary public So the notary public need not be called to court to prove that is it your signature, unless the defendant takes up the plea that such notary doesn't exist under the Notaries Act. ये मर चुका है, maybe not there, and entries are fraudulent. So you have a right to examine the notary as a party. So in Bombay city, in everywhere in India, people are making bogus affidavits. इलेक्शन के अंदर देखेंगे आप, रिप्रेजेंटेशन ऑफ पीपल्स एक्ट के अंदर सेक्शन 81 82 में सेवरल पिटीशंस आर फाइल्ड इन द सुप्रीम कोर्ट एंड हाई कोर्ट challenging the election. The court is coming to the conclusion that several affidavits are bogus. So notary public, maybe in practice it should tally with your serial number, not tally. Many notaries may be known to you, people are standing on the road and pay them some few bucks and get it reported. That we have a right to challenge it. Otherwise, there is a authenticity, there is a respectability attached to the document. The court shall presume they are good documents. Okay. Similarly, under 85, a presumption as to electronic agreements, the court shall presume every electronic document to be agreement to be correct. Presumption as to electronic record, digital signature, see that here 85B ke andar presumption arises. Then 85C also, certificate issued by the authorities under the Information Technology Act, the court shall presume they are valid one. Then the presumption arises, presumption certified copies of foreign judicial record. So when a judicial certified copy of the order is passed, now section 86 is to be read along with section 14 of the Code of Civil Procedure. So when you seek to enforce the foreign award, foreign judgment in the city of Mumbai, in Calcutta, Madras, Bombay, anywhere, the court will accept the certified copy as a true document unless the other side takes up the plea that such a dispute never arose. Okay? So these are the shall presume examples in the court. Now the last example is conclusive proof. With that I will stop it today. That is a section 4 आ जाइए आप. I will just give the illustration. Time कितना हो गया? हिमांशु? गीतांशु क्या? Time कितना गीतांशु?
Almost 8:30, sir.
8:30 हो गया. Shall we stop it here? I think
so we can finish section 4 that you have taken up.
Night time लगेगा इसका. I think this will take consume another 45 minutes. So we will stop today now. Anybody want to ask me questions so far? बता दीजिए. I will take up the conclusive evidence. Maybe if not Friday, I will take it on Saturday. Okay? I will let you know. Maybe Friday I am not in Bombay. I will come back Saturday. Saturday I will take one or two lectures. Maybe 7 o'clock to 6 to 7 or 6 to 8. Is it okay? Saturday, you are comfortable, all of you?
Yes, sir.
Yeah, yes, I will. My next lecture will be Saturday now. Okay? Or anybody want to ask me any question so far? Please ask me.
So, quick question, sir,
yes,
regarding today's judgment of Mr. M.J. Akbar. Now, what happens to him, sir, legally? What is the next step? Supposing he is not able to disprove what has been proved today, that he is a man of dubious character, then what happens as a legal standing of a person? So what happens? Like,
see, he had filed a complaint under section 500, 501, 502 that on the ground that definition of defamation is section 499. That I have been defamed, I am a respectable journalist, I enjoy good reputation. So the learned magistrate before whom the evidence was recorded, the accused Ramani has been able to establish before the court whatever she has said in the newspaper about his character is correct, and he is a man of no character and he has no reputation. So that means his defamation case doesn't succeed. She will not be convicted. She is honorably acquitted, and it's one more feather in the cap. That's all. And as regard Mr. M.J. Akbar, the avenue open to him in the case of acquittal, he has to file an appeal. That appeal will go before the High Court. समझे ना आप? And that is how it is. Otherwise, he may choose not to appeal further. It is possible.
Okay.
You know that under CRPC, you have learned from the scheme of the CRPC. What are the appeals which go to High Court and Court of Sessions? You know that appeal against acquittal go to the High Court. मालूम है ना आपको? पढ़े ना आपने? भूल गए CRPC के अंदर.
Yes, sir.
Yes. Any other question?
Thank you, sir.
Shall we wind up then?